Hello guys, welcome to The Council Seeks Ignorance. Today I'll be dealing with section 4 onwards till 3 I had dealt with in my last video. From section 4 onwards, the act actually starts doing the real work. This is where we answer 4 questions. First being, when can personal data be processed? Second, what does valid consent actually mean? Third, what are data fiduciary legally responsible for? And 4, what rights and duties do individuals have? So if you understand section 4 to 10 properly, you actually understand 70% of that. If we get on to section 4, it talks about grounds for processing personal data. Section 4 is the gateway provision. It says that the personal data can be processed only for lawful purpose and only on 2 grounds, that is consent, and second is certain legitimate uses, nothing else. So what is lawful purpose? A lawful purpose simply means a purpose not expressly forbidden by law. So if an activity is illegal under criminal law, contractual law, etc., you cannot sanitize it by taking consent. For example, a betting app cannot say, "Hey, you consented to us running an illegal gambling operation." So the consent does not cure illegality. Coming to section 5, it talks about giving notice. Giving consent does not come out of thin air. It should precede like giving a notice. So before asking for consent, the data fiduciary must tell the data principal what data is being collected, for what purpose, third, for how rights can be exercised, and how complaints can be made to the board. So for like if I give you an example or an illustration explaining the same, it'll be when a bank does video KYC, it must tell you your video will be recorded, why it is being recorded, and what rights you have if something goes wrong. So if consent was taken before, and additionally, if consent was taken before the act came into force, the data fiduciary must still send a fresh notice explaining the ongoing processing. This means the old database are not grandfathered blindly. So the next section is section 6, which talks about consent. This is the heart of the act, and this is something that I have already dealt with in the introduction video, which I'll request my viewers to watch. So I think this will be the most litigated section in the future. This talks about that the consent must be free, specific, informed, unconditional, unambiguous, given by clear affirmative actions. So if I give you a question where I ask you if pre-ticked boxes are valid, so the answer to it will be they are invalid, and so is bundle consent, that's also invalid. If I ask you a question where I tell you that, I give you an illustration where I tell you that a telemedicine app is asking for a health data access as well as phone contact list access. So is it valid, and what part of it is valid and what part of it is not? So only in this situation, only the health data is necessary. The contact list access fails the necessity test. Uh, if I go further on this section, it talks about if a part of the consent violates the law, only that part is void, not the whole consent part of it. Example, if insurance app says you consent to policy issuance, second, you waive your right to complain. So the waiver clause dies, the rest survives. Next is in this section only withdrawal of consent. So consent can be withdrawn, like this act says that the withdrawing of consent should be as easy as it was for you to give the consent in the first place. Um, but here's the key legal nuances students miss, that withdrawal affects future processing and it does not invalidate past lawful processing. Example, you ordered goods, you paid them, and then you withdrew the consent. So the company can still deliver what you paid for even if you withdrew the consent before you withdrew your consent. If you placed your order before withdrawing your consent, the company can still use that data to deliver that product to you. And if we see where who has the burden of proof in such situations, so if a dispute arises, the data fiduciary must prove that the notice was given, and then second, that the consent was valid. This reverses the usual evidentiary comfort companies enjoyed in the past. Next section that we are going to deal is section 7, which talks about certain legitimate users, which again I dealt with in my first introductory video, but not with the sections. It was a clear like just for the introduction part of view. So it talks about that the consent is not always required. This section actually prevents the act from becoming unworkable. So consent is not required in the following cases, such as voluntary, if first being the voluntary provision of data for a service, second, government subsidiaries and benefits, for like if the government is providing government subsidiary and benefits, third, legal obligations, fourth, court orders, fifth, medical emergencies, sixth, public health crisis, seventh, disasters, eighth, employment related processes. So for employment example, and I'll give you an employment example. If an employer can process employee data to prevent corporate espionage, second, protect trade secrets, and third, provide employment benefits. But this is not a blank check. Processing must still be proportionate. Next is section 8, which talks about general obligations of data fiduciary. This section answers one question, that is, who carries the legal risk? So the answer is always that the data fiduciary carries the legal risk. Key obligation include data fiduciary remains responsible even if a processor messes up. Second, that the processor must be appointed under valid contract. Third, that the data used for decisions must be accurate. Fourth, the reasonable security safeguards are mandatory. Fifth, data breaches must be reported. And sixth, and the last, data must be erased once the purpose is served. Erasure rule, if I explain the erasure rule, it's more like data must be erased when consent is withdrawn or the purpose is no longer served. So unless retention is required by the law, then the data must be erased when consent is withdrawn or purpose is no longer served. If I give you a banking example, even after account closure, KYC data may be retained for 10 years due to statutory requirements. This section balances privacy with compliance reality. If we go on to section 9, it talks about children's data. This is something which I thought was not really important, so I didn't make a PPT for it, but I'll explain it in simple words. That this is where act becomes paternalistic, and intentionally it becomes paternalistic. This is something which is covered more in the rules, which we might deal in my upcoming videos. This section tells that there should be verifiable parental consent, which should be mandatory. No processing should harm child's well-being. There should be no tracking, no behavioral monitoring, no targeted advertisements. So the central government can relax this for certain platforms only if the safety is verifiably ensured. So default rule is that children are off limit for profiling under section 9. If we come on to section 10, it talks about significant data fiduciary. So this is something which is also dealt in the rules. Rules is something you should also read with the act. Section 10, this is a risk-based regulation. The government can classify entities as significant data fiduciaries based on volume and sensitivity of the data, or risk to the rights, or impact on sovereignty, elections, public orders. And additionally, for extra obligations, such fiduciary must appoint a data protection officer in India, conduct data audits, carry out data protection impact assessment, and undergo periodic compliance checks. Think of this as India's version of GDPR, EU GDPR, UK GDPR, sorry, and high risk processing, and it's like a high risk processing framework. So we have come to the end of the video. Quick recap. Let's compress section 4 to 10 into 1 minute. Section 4 talked about two grounds only: consent or legitimate use. Section 5 talked about no consent without notice. Section 6 talked about consent must be real, revocable, and etc. And section 7 talked about consent exceptions. And section 8 talked about fiduciary is always carrying the responsibility and liability. And section 9 talked about children's getting protected under this act. And section 10 talked about big data players, which are called significant data fiduciaries. So if you treat DPDP as a right statute alone, you will miss the point. It is equally a compliance and risk allocation statute. This is the end of the video. Thank you so much for watching. Please do subscribe, like, and share, and do comment also. Do let me know if you like this video and if there is any which ways I can improve, because I'm just so new to it.